From time to time, CEOs and business owners have asked me, what should they expect in a dispute with a disgruntled ex-employee? How does that process usually play out? What are the different stages? What are the steps, the legal considerations, and the ego and emotional considerations at play here? I've worked with a number of companies who have dealt with difficult employees who they've had to let go. Often that termination meeting didn't go well, or there might have been months leading up to that didn't go well. You may have an employee who is disgruntled, angry, and frustrated. Maybe that employee feels entitled to something. They felt like they weren't paid enough, and it had nothing to do with their performance. It had something to do with maybe a classification that they're in, like ethnicity, gender, age, religion, etc. Whatever the reason, employees who are terminated often bring claims of wrongful termination, discrimination, violations of whistleblower protection, hostile work environment, or other sorts of claims of illegal employment conduct. And so as a business owner or CEO, it's helpful for you to understand, what does this look like? First, if you have employment practices liability insurance, which is abbreviated EPLI, you can typically take those claims and turn them right into your insurance company. So once you start getting 10, 15, 20 employees, that's typically the point you start to think about, maybe we should just get some insurance, because if we have one claim of employment misconduct, you'll probably spend many times more in legal fees than you would having that insurance policy in place. So I always encourage business owners of mid-size and larger companies to have EPLI, or Employment Practices Liability Insurance. It's usually not too expensive, and it pays for itself many times over the first time you have some sort of legal issue. All right, so let's say if you have insurance policy in place, you can turn the claim over to the attorney and the attorney will handle it. If you don't, you typically will hire an attorney, because what happens is that employee goes out. They will typically look for an attorney who will work on a contingency basis. In other words, the employee probably isn't going to pay an employment attorney an hourly rate, because usually employees don't have that kind of money. And so the entire legal profession around employee rights is based on contingency work. In other words, the attorney says, you don't have to pay me by the hour. I get a percentage of whatever I recover for you. So the employee goes to an attorney in an employee rights law firm. Now, I can tell you, on average, statistically, that law firm will reject 19 out of 20 potential cases. Why? Because most people who got fired think it was unfair, but unfair is not the same as illegal. So the law firm is going to look at not just was it unfair, but was it illegal? Did it specifically violate some law? Typically that's going to be discrimination on the basis of race, religion, or one of the other protected classes. It's going to be some sort of sexual misconduct on the part of management, negligence regarding sexual assault, or discrimination on the part of management. It might be a whistleblower claim, or it potentially could be a hostile work environment. But what most people think is a hostile work environment is just rudeness and jerks. It has to be pretty bad, pretty hostile, in order to actually reach the level of being considered hostile in a legal setting. So The employment attorney will consider all these cases, and even if something illegal happened, it doesn't mean the attorney will take the case, because the attorney has to think now, how much money can we recover? And usually, attorneys say to themselves, we need to recover on the cases we win about 3 times whatever our normal hourly rate would be. So think about it. If the claim is for $1,000, the attorney may say, I can't take that case. Even if we win, it's too small. I would get a third of $1,000. That's just not enough. Now, some statutes allow for the recovery of attorney's fees or other sorts of penalties. And so in those cases, employment attorneys may be able to recover enough money to justify taking the case, even if the case is small. One example of that is often a dispute over how much the employee was entitled to receive. If the employee was working overtime and not receiving time and a half, or if the employee was paid a salary and should have been getting paid by the hour, which would have resulted in a lot higher pay, those are cases where, at least in Minnesota, the statute allows the attorney to recover more than just the amount of money the employees owed. There's typically going to be a penalty and a right to attorney's fees, at least after certain points. If an attorney takes a case, usually it's on a contingency basis. Now, the attorney documents everything the employee says and typically puts together a demand letter to the employer. The employer will typically read through that and often disagrees with a lot of it. Usually it's the best practice for the employer to hire an attorney at that point to articulate a response. And here's why. Because employers often will sit and argue over things that are not important but were included in the letter. An employment attorney understands what's illegal and what's not, and how to limit a response to the legal issues, and simply note that we're not going to get into a petty squabble over little issues that are not legal. Of course, in every situation, there are all sorts of details and people can argue until they're blue in the face. That's not important. An attorney is going to stick to what are the big issues that actually could be a loser for the company in court, and will either address those factually or point out what the law is. Now, typically the attorney representing the employer, the company, is going to talk with the employer about potential exposure, maybe mistakes that were made or risks that they have. And usually these cases are negotiated and there's some sort of settlement. Now, it could be that the employer knows that they have a very strong case, but they'd have to fight it out in court, and they don't want to do that. And so the employer says, you know what, we'll offer a little, even though we're not wrong, we just want to make this go away. We'll offer a few $1,000s. And typically that's part of a response letter which says, we didn't do anything wrong, but to make this go away and to resolve it without any admission of liability, we'll offer X amount. Maybe it's $2,000, maybe it's $5,000. But other employers, and some big Fortune 500 companies are known for this, say, you know what, we're going to fight every single one to the end. Because once we start paying out to anybody who brings a claim, we're just inviting more employees to bring claims against us, even though there's no merit to those claims. We need to establish a reputation that we fight these to the end, and that sends the message to the employment attorneys, you better only bring good cases, because if you bring frivolous cases, you're going to have to fight them out in court, and we're going to even try to get attorney's fees for you bringing a frivolous case. So it puts some pressure on the employment attorneys taking this case on a contingency basis to say, do I really want to take this case and fight it all the way out to trial, which might cost a couple $100,000 in legal fees? Is it worth it against this employer? When employers have established that sort of reputation, the employment attorneys don't take a lot of the small and weak cases. But most small businesses, don't have enough claims against them to establish a reputation of that type. Also, small businesses don't have the kind of legal fees to fight these cases for years. So, because the small businesses don't have a budget, often they will do some sort of severance payment or separation payment just to make the issue go away. But it really depends. It depends. Sometimes employers just say, you know what, it's about justice and doing the right thing, and I'm not going to pay this person who caused so much trouble for our business. I'm not going to pay him now again due to some sort of frivolous claim. So that's what that conversation usually looks like between the employment attorney representing the company and the business owner or business CEO. You may have some correspondence go back and forth between the employee's attorney and the company's attorney. You might have some mediation. Maybe they agree to go to some sort of mediation, which often suggests that there's going to be some sort of settlement there. Parties usually don't go to mediation if they are dead set against some compromise. The purpose of mediation is to acknowledge there's room for compromise. Let's see what that looks like. And then sometimes these cases go to court. And it can be very time-consuming for an employment attorney to take these kinds of cases to court. Usually employment attorneys only want to take the good ones. Likewise, it can be time-consuming and draining for the company because whenever you're in a lawsuit, it's not just money for the attorneys. It's the stress. It's the sense of injustice that eats at you on a daily basis. Your friends and family ask about it, so you're talking about it. It's a very negative, toxic conversation. And also for a business, it can really interfere with running the business if you are having to gather up data in response to discovery requests. That's where the employment attorney representing the employee asks for information they're entitled to during the normal exchange of information in a lawsuit. The employment attorney can ask for documents, computer evidence, and any other information relevant to the issues in dispute. The employment attorney can do depositions of any employees who have knowledge about the situation. So that typically means they're going to subpoena and have a deposition where they ask questions of coworkers and managers of the ex-employee. This can be intrusive. It can reveal a lot of information into a public court that the company might desire to keep confidential. And it's just a distraction from the normal operations of running a company. It also really can affect morale. So if you are a CEO or a company owner, this gives you an idea of what happens in an employment dispute with an ex-employee. I'm Aaron Hall. I'm an attorney for business owners and entrepreneurial companies, and I do these educational videos to help people understand what are the issues that get faced in a company, how can you mitigate risk, and what are the issues and questions to bring up with your own attorney. You can learn more about me at aaronhall.com, and if you want a free resource that covers common problems in businesses and how to avoid them, go to aaronhall.com/free. When you go there, you enter your email address, you'll receive the guide by email, and then you'll also have access to videos that explain how to avoid some of the other common problems faced by business owners so that you can avoid legal trouble in your company. I'm Aaron Hall. You can reach me at aaronhall.com.